founder. I'm the founder and executive director of Immigrant Connection. I'm accredited by the Department of Justice to provide immigration legal services. I've been in the immigration legal space for about 11 years, and I lead a group of immigration offices that kind of stretch nationally. I thought most of my work would be done in a lot of other sectors, and I find that most of the work we do is with workforce partners, including restaurants and hotels, because you, like us, love immigrants and know the value that immigrants bring. And so helping immigrants navigate complex processes and helping those that care about immigrants navigate complex processes are things that we often do together. And so we'll get started in the presentation. The goal today is to give you at least an overview of some of the important things that you should be thinking about. These are things that I know probably aren't things that you think about on a regular basis, and so we're going to highlight them. And so we're going to talk about things that again you don't necessarily think about on a daily basis, like how to run your business and the regular day-to-day operations. These are things that are we want you to think about now to protect yourself, understand the rules and the laws and the policies, and make sure that you're prepared to keep your business safe, your employees safe, and that you are have at least a basic understanding of some of the ways to navigate future changes. One of the things I just want to highlight is that this will only be an overview. We don't have time to go in depth into things. I would encourage every business on the call that if you don't already have an attorney that is an expert in both like employment and immigration, to find one, because again, we hope that an I-9 audit or a workplace raid doesn't occur in any of your businesses, but they could. We're going to start with something that like just touches on this. If you've never got a Social Security Administration no match letter, these are letters that these aren't related to I-9 audits. I-9 audits are things that immigration does. No match letters are more of an IRS thing. This is when someone like you fill out things for an employee and you get a letter saying there's some discrepancy. The most important thing to know about no match letters is this doesn't mean that your employee has done anything wrong. It doesn't mean that you need to terminate the employee. It doesn't mean that there's something wrong with the employee's immigration status. No match letters are things that share there's a discrepancy. And so one of the best examples I can give is oftentimes when someone gets married, if they work for you, it's like their social security number might match a name that doesn't match, the name that's in the system. And so if you get a social security no match letter at your place of business, you should call the employee in privately, discuss it with them, and then it's up to the employee to work with the Social Security Administration to rectify that information. But the key to understand is like you shouldn't do anything when you get these no match letters. I know that they're confusing maybe the first time you get them, but you don't want to like do anything that adversely affects the employee. You want to explain it to the employee and let the employee kind of work things out. Oftentimes, especially if there are immigrants from lots of countries, you and I probably both have friends that depending on what document they show you, sometimes there's multiple last names, sometimes there's just one. Same person, just like sometimes when it comes to content and names and things like that, there are discrepancies. And so that's why you get those letters. Moving to like how the Department of Homeland Security would work with this. If there are, I mean, there are certain industries where this happens more likely than others, like hospitality and construction, agriculture, meat processing, where there are enforcement tools that DHS has to make sure that the employer is doing everything correctly according to immigration law. And so the one thing that they do is I-9 audits, where they will request to review your I-9 forms, and they make sure that they are correct. And if they aren't correct, you would face fines. Sometimes, if you're a large enough workforce, you can even be required to enroll in E-Verify, which kind of does a lot of that verification for you. The other thing that DHS can do, ICE can do, is worksite raids. And this is when they would come unannounced to your place of business, looking specifically to detain and arrest individuals they suspect are present in the United States without authorization. So we're going to talk about both of those kind of in detail, or as much detail as we can, and then how you can prepare as an employer related to both of them. And so when it comes to I-9 audits, one of the things you can do to prepare are what we would call self-audits. This would be, and again, I know that I'm someone who ran a coffee shop at one point in my life, and thinking about like, you do the I-9 when someone first comes to work, and then it probably sits in a filing cabinet somewhere and you don't think about it again. We would encourage you to think about it again during this season. We would encourage you to do a self-audit. You should get training on that, but I will say like there's two ways to do self-audits. You could either do comprehensive where you're doing all of them, or you would kind of do a spot audit. Just be careful with spot audits because you don't want to show discrimination. Like you don't want to just pull certain people. Like you want it to really be a spot audit where you're looking at a wide variety, not just people like with certain last names or from certain places. You do a self-audit so you can make sure that your I-9s are filled out correctly, and that also gives you a chance to correct the I-9s that aren't filled out correctly. This also gives you a chance, again, if you're like a lot of people, when you do I-9s, they sit in a file and you might not go back to them. There is a retention rule about I-9s. If you have a current employee, you need to retain their I-9. But if an employee left or was terminated or no longer works for you, you only have to keep it for 3 years after the start date of employment or 1 year after the last day of employment, whichever is later. And so for some of you, if a lot of your people stay long terms, it's 1 year after the last day. For others of you that if you kind of have low retention, you're keeping them for 3 years after start day. If you ever had a real audit where ICE came to request the documents immediately, realize that you're given currently 72 hours. It's not like you have to go, back to your office and hand things over immediately. You're given 72 hours. That can change. That's a policy that could change based on what the administration might do. We would encourage you that if you actually get a real audit from ICE, that you contact that attorney. That's why finding out who might be the good attorneys in your area. And I imagine most of the restaurant associations or like hotel associations would recommend certain people that could help. You only have to turn over the files that are requested. Oftentimes it isn't everything. Sometimes it could be. And you never just want to turn them over without making copies yourself. That's just some best practices. The most important thing, though, today is like if you would know and make sure that you're filling out your I-9s correctly from the beginning, it will make this not as much of an anxious time as it could be. And so we're just going to give a brief overview of this. And maybe you're on the call and this isn't what you do, this is someone else. I would encourage them to like watch this part of the video because again, it's a form that's really important, especially now, thinking that audits will probably be heightened. So there's a couple sections to an I-9. It's actually a USCIS or U.S. Citizenship and Immigration form. The first section isn't filled out by you. It's important that the first section is filled out by the employee themselves. And so all you're doing is verifying that they're actually filling in all of the blanks that they need to. And then it needs signed and dated. A few quick things to keep in mind that often employers struggle with on Section 1 is you need to make sure everything is filled out. Obviously, there's not always a Social Security number that needs filled out. Sometimes you might have a non-citizen and things like that that is going to check the box, and then make sure if you check box 4 that you're filling in other information. So box 1, a citizen of the United States, you're just checking that box. But on Section 1, box 4, if you check that they're a non-citizen authorized to work, you have to share the expiration date. They're authorized to work until that date. And then you have to share information related to either their A number, which is an immigration, an A number is the alien number, their I-94 admission number, or the foreign passport number. When you're doing I-9 audits, just make sure that if box 4 is checked, that those things are filled out. The other thing to check on Section 1 is to make sure that it was signed by the employee. And maybe the most important thing, or the error that's made the most, is that the date isn't filled out. And this is the one to make sure. The dates on I-9s are very, very crucial. We want to make sure that employees complete Section 1 on or before their first day of work for pay. And so if you go back in and you're doing I-9 audits and that didn't occur, this would be one of those things that you'd want to like make note of. But you don't do I-9s after. I-9s, the Section 1 has to be done on or before the first day of work for pay. You can do it beforehand. I know there's some industries that when you give someone a hiring thing, even if they don't come to work until like the next week, it's like, let's get this done now. So make sure, especially those bottom two things are done. And if you mark set number 4, you're filling out more information. When it comes to section 2, this one is done by someone on your team as the employer. And usually I would encourage, again, this is just from experience being a little bit in this sector as an employer at different times in my life. You want one person who is trained to handle this so they kind of know to make sure things are done correctly. Sometimes I know we're busy, and so there's a lot of people involved in this. It's like training one person to do it. Section 2 has to be done within the first 3 days of the employee's first day of work. So you have a little bit more time to do this, but it has to be done within the first 3 days. Like this isn't something that months later you come back to. This is verification that's supposed to happen upon employment. This is that thing that if you've never filled out an I-9, there's different lists. And to be lawfully employed in the United States, you have to prove your identity and also that you're allowed to work. There are certain documents that you can look at, for instance, a US passport that proves both of those, or a birth certificate. Like it proves that I am who I say I am, and that also gives me the eligibility to work because every US citizen is lawfully able to work. There are other documents that either prove identity or work authorization. So if you show like a foreign passport, for instance, that proves the identity of the person, but they would also have to have another document that proves work authorization. So a lot of times that might be something like, it could be a refugee card. It could be it's called an EAD, an employment authorization document. And so if you're choosing something from list A, and the instructions of the I-9 form explain every document that counts for list A. You only have to do one document. It proves both. If you're doing something from list B and list C, you need one from B showing identity, one from C showing work authorization. The error that is most made, at least what I've seen most made on section 2, is that things are not filled out entirely. So someone just writes the document title, like kind of passport, but they don't fill out the issuing authority, the document number, the expiration date. Couple other things to keep in mind. You have to see originals of the document. The only thing that doesn't need to be original is a certified copy of a birth certificate. But like you can't just see a copy of a passport or a copy of an EAD. You need to see the original, and it needs to be unexpired. And so someone can't show you like, this is an old document I have. The person that fills that out is not the employee. It's someone that the employer designates. They'll fill out the bottom of section 2, their name, their signature, the dates. Remember, the date has to be within the first 3 days of work. By the way, the other error that happens often in section 2 of the I-9 is there's 2 dates on section 2. The one date, if you'll see, is the first day of employment. Like that needs filled out. The other date is the date that you actually did section 2. So those 2 dates need to be within 3 days of each other if the I-9 is filled out correctly. When it comes to working with immigrants and employing immigrants, oftentimes you will have to also fill out what we call section 3, or it's supplement B. This is because a lot of immigrants might be in a temporary status. Again, there was a great updates early on in the call. We know that there are more immigrants than ever before that are in a temporary status, meaning that they are lawfully eligible to be here, lawfully eligible to work, but there's an expiration date. Those are like our DACA recipients, Those are temporary protected status. That was like humanitarian parole. Those are asylum seekers. Because of that, when you're filling out an I-9, it means that there's going to come a time where you have to re-verify that the immigrant is still able to work. I would encourage, if you work with a lot of immigrants that have temporary status, that there's a way that you remind them and flag them. Like, there's nothing worse than, like, no one wants to lose a good employee. So it doesn't make a lot of sense to call the person in the day you need to re-verify and say, hey, do you have your new documents? I would encourage any employer. We work with a lot of employers. My offices do a lot of renewals for immigrants related to their EADs and their immigration processes. And our best practice is, if employers would remind their employees 180 days before you need to re-verify, that gives your immigrant employee enough time to get with like someone like me or our offices or other offices around the country and make sure they have the time to do the renewal they need to get you the new document they need to, so that there is no interruption in work. So Supplement B is all about re-verification. You're going to have to look at a form again, put in new information. This is also when you rehire people, you fill out Supplement B, because you might still have their I-9 on file, and this happens again. Not so much in restaurant work, but if you have friends in the ag business, this is also what happens when you have someone on a temporary visa that needs, like, they get rehired every year during harvest. So that's how you fill them out correctly. Let's just all be honest that probably at some point we didn't fill them out correctly. So one before that, I think we have a slide. If you need to correct them, again, if you want to audit all of yours or you want to do spot audits, you can get more information on how to do that. But on section one, if there are errors, again, section one isn't for you, it's for the employee. You can have the employee correct errors. And the way that you do this is, like, you don't use whiteout. Like, that's maybe one of the most important things to know in an I-9. Like, you don't want to act like you're trying to hide things. You just mark a line through the air and you enter the correct information, then you initial and date it. Section one is done by the employee, section two by the employer. If you ever feel like, oh my goodness, we really like messed this up, we got the wrong documents, we have the right ones now, you can complete a whole new I-9, but again, related to these audits, you don't want to throw away the old one. You want to staple the new one to the old one, and you want to explain kind of why the error was made and why you've made the correction. There are times related to an I-9, for instance, that someone might come to you and say, like, hey, I've been working for you for a long time. I want you to know that I got, my immigration paperwork was completed and I want to correct some things. And, like, again, you don't have to do anything, like nothing adverse in them. Like, you would just correct things, staple their new I-9 to their old I-9, and explain that there were new documents presented and you were putting those on the I-9. The reason why this is all important, and this isn't to scare you, but there are some pretty big consequences related to non-compliance. If you have an I-9 audit, and there will probably be thousands done this year, there are monetary penalties. They vary based on, like, if this is something that's happened often or this is the first time. They're varied based on, like, did you actually know this was happening and you've corrected it? Was it so substantive? Was it, you violated things like a bunch, or just like it was once? A big one that can happen is a debarment, where if you knowingly hire and continue to employ, you're not allowed to participate in federal contracts or receive other government benefits. So, like, more than a fine, sometimes you can kind of be removed from eligibility for some programs. There is even criminal penalties that exist if you have a constant pattern of hiring unauthorized workers. And then the last thing is there's mitigating factors. Like, all of these fines, depending on how big your business is, depending if they believe like you made the mistakes on purpose versus like you're trying your best to make sure these things are done according to plan, like, there's mitigating factors. Most of us in this space feel like those fines may go up. Obviously, we're not sure. My guess is the team at ABIC will keep you informed as things change, as well as your associations you're a part of. But all that to say, the best thing you can do now to mitigate any of this risk is Make sure you're filling out I-9s correctly. Make sure you're reviewing them and auditing them. Make sure there's someone at your team who's kind of the expert on this, so that if an I-9 audit came, it would be like, not like, oh my goodness, what do we do? It's more like, oh, we've made the corrections. We know that we've made errors in the past, but we also know we've caught them and we're doing things correctly moving forward. So the next big one, and I'm going to move quickly here. I apologize. There's a lot with I-9s because it's a government form, is ICE enforcement. Like, how do you know you're following the law? And let me start by just saying this. I know this is hard. I do a lot of these presentations. I was telling the team I'm doing 17 presentations today between businesses and schools and churches and things. ICE and the government is not the enemy. The goal here is not to act like, if ICE comes, they're doing anything wrong. But the goal here is to prepare you. How do we keep you as a business safe, your people safe? How do you make sure that you know the rules, the rights and responsibilities you have? The best illustration I can give is like taxes. I think most of us, there was a time I did all my own taxes. Now I don't, because I want to make sure I follow tax laws that's currently written, and it's too complex. So I don't want to do too much, too little. Like, I use an expert because they know kind of the guardrails and the rules of engagement. Well, we're trying to give you at least a basic knowledge of ICE enforcement, what the rules of engagement are. When it comes to ICE, you really need to understand the difference between a judicial warrant that is signed, dated, and filled out and anything else. Oftentimes, ICE might show you another document that looks very official. For instance, what is shown on the left side of the screen is a warrant of removal or deportation. ICE also has arrest warrants. There are all kinds of other documents ICE might show you. But you need someone on your team that's a point person that knows what a signed judicial warrant looks like. The reason why is, other than in public space, the only way that ICE can enforce things in private space, in your hotel, in your restaurant, is if they have a signed judicial warrant or you give them consent. So what could happen is if you're not trained in this, you see a document and you feel like, oh, I just need to give consent. Knowing when you have to give consent and when you can choose to say, I have the right not to give consent unless you show me a signed judicial warrant, is important. Again, this isn't saying like ICE isn't the enemy, the government isn't the enemy. It's just, how do we know our rights and responsibilities when it comes to ICE enforcement? Whoever your person is, we would encourage you to have a trained point person every shift and every location you have that actually knows this, so that if ICE came to your front desk or your lobby, you could tell your employees, like, we're going to get the point person. That person would come and be the spokesperson with ICE. They would ask, like, do you have a signed judicial warrant? That person needs to make sure that it is signed. A judicial warrant needs signed, dated, and then there needs to be like the name and address. And so let's just say they give you a signed and dated judicial warrant, but it lists another address and building. Your point person would be able to say, like, I'm sorry, this judicial warrant isn't correct. This isn't the location that you have the ability to come, and we don't give you consent to come and do anything. The other thing to keep in mind, and this is just something that we think is important, oftentimes when it comes to ICE enforcement in a business, there are what's called collateral arrests. ICE might be coming looking for one individual at your workplace, and it could be that they arrest others. And so we think it's very important that that point person looks at the judicial warrant, and you could see if the person is present at work. And you could tell ICE that, if the person didn't show up to work that day, the person isn't here. We can affirm that. And so we don't give you consent just to come in and look to avoid collateral arrests. So the first thing you want to do is confirm that there is a judicial warrant. Make sure you know what the scope is. Oftentimes it will share where they can be on your property. And so that point person would want to go around with ICE to make sure that they know they're going to the places that are allowed on that warrant, and other places that aren't a part of that warrant, they're not able to go. You just want to make sure that they're following the law and they're not going any place that they're not legally allowed to enter. You need to be truthful. You don't want to interfere. You don't want to escalate the situation. Like I tell people, and again, you could talk to your own attorneys about what they would recommend you do. I never think it's a good idea, to be argumentative, to take out your phone and say, I'm recording, but you should ask for their name and badge number so that you have a documentation of that. If you happen to have third-party work sites and contractors, it's completely right for them to say this isn't our space. We need to confirm with the people who actually are over this space, and they would be the ones that would work with you related to being able to be on the property or not. We talk about this the next slide, like definitely the most important thing you can do, have an action plan, have a point person. We've kind of gone over that. The point person should know, don't just have your morning manager like teach every shift, every site. They would be the ones that know what a judicial warrant is, communicate with the agents, make sure you're following the laws and policies, and recording the badge numbers and names of the ICE agents. Finally, I would explain, you know, don't just give consent. Like you don't have to do that. Like you have the right to not give consent without a warrant. And so don't feel like just because there's an ICE interaction, you have to do anything that your rights don't afford you the ability to do. You can speak with and be represented by an attorney. We would encourage you that if ICE comes for an employee to remind that employee of their rights. They have the right to remain silent. They have the right not to sign anything. They have the right to counsel and an attorney. So I would definitely, again, this goes all the way back to the main thing, like having a good employment immigration attorney or firm that you could call makes a lot of sense. Again, if ICE comes and they want to do an audit, remember, you don't have to do that immediately. You're given 72 hours. Final thing, and then we're going to take questions. I just want to share with you a little bit about Immigrant Connection. We work a lot with workforce because we want to stabilize the workforce. So if you have immigrants that have lots of questions, like that's something we can help with. If you go to that website, ICOven.org next steps, we can work with getting legal professionals to guide immigrants on like, are there pathways for me and my family? The other thing I want to share is we didn't talk about this in this session. This one was about you. But if you as an employer want to say, how do I help my immigrant employees right now? Like, how can I educate them on their rights, on plans they need to take to help keep them safe and stable? We do a lot of that training with workforce where you might have an HR person or a manager who says, I just want to help my immigrant employees understand how to prepare themselves in this time. Please reach out on next steps and let us know. We do those trainings regularly. We want to train you so that you can be a conduit and help your employees navigate this time because let's be honest, it's like a maze with moving walls. And so we need people who can guide and protect people in the midst of that. So I think I gave time for questions. So feel free to ask your questions. I might not have all the answers, but we have the ABIC team as well who can help.
Great. Thank you, Zach. That was super helpful. There are a lot of questions, and so we definitely will not be able to answer all of them, but I'm going to try and focus on the questions that are asked multiple times or ones that the information wasn't covered in the recording. First, the two most common questions I'm getting are, yes, we will be sharing the slides out with folks after the fact. We will also share out a recording of this presentation to you as well. So both of those will be available. So the first question that I have for you, Zach, is there adverse action that can be taken against an employer if the employee does not resolve their no match letter?
Not that I'm aware of. James, do you have another? No, that comes to you so that you can let the employee know, and then the employee's role is to work with, and then if they sort things out, they'll let you know. But there is an adverse action that can be taken related to that.
Yeah, as far as I know, the only responsibility an employer has with Social Security no match letters is to notify SSA that you have notified the employee that you received the letter. But beyond that, no. Is our I-9s only for current employees or for all employees? For all of
So
for the entire business?
Yeah, so you would keep like, yeah, like you should be doing an I-9 for anyone you hired. And so if they're currently employed, you would keep them on file. Then you should be going through your I-9s regularly so that if someone is no longer employed, you either have to keep it for 3 years from start of hire or a year after they were terminated. So if someone worked for you for 5 years, you only need to keep it for one more year. But if someone worked for you for 1 year, you need to keep it for 3 years. So it's not like you need to keep an exhaustive database so that you have I-9s for everyone that's ever worked for you for the past 50 years. It's only current employees, and then if an employee is no longer with you, you have to keep it for a set amount of time.
Gotcha. And if I am using E-Verify, do I still need to complete I-9 forms?
I work with a lot of companies that use E-Verify, and I think it's just all in E-Verify now that you have to do it. I know sometimes it gets complicated with certain things that temporary workers and things like that E-Verify, you might have to get flags you and you have to input data. But I'm not an expert other than knowing companies that use it. And I think E-Verify does everything for you internally. I don't think there are paper I-9 files. James, do you know? I've never seen them. I've only worked with companies who say E-Verify flagged this person. I need to do something. I don't think there is paper anymore.
Yeah, all of what you would put on an I-9 is what gets entered into the E-Verify system. So as far as I know, you do not have to
You
do
don't have
that
to
redundancy
duplicate,
for
yeah.
both. Okay. If I'm hiring from a temp agency, do I need to fill out I-9s for folks I hire from a temp agency?
Well, so that's one of those unique things. Like if you're using a temp agency, you're not hiring the temp agency. They're employed by the temp agency. You have a contract with them. But if you take someone from a temp agency and you choose to hire them and they become your employee, at that point you have to fill out the I-9. So I know it's sometimes unique. I think a lot of people use temp agencies as an on-ramp, but if ever the person moves from the temp agency who you're contracting with, at that point they're not your employee. Like, but when they move over, they become your employee, and you'd have to fill out your own I-9s, if that makes sense. And so, like, I know it can be confusing, but if they're just you're working with a temp agency and and I guess James, correct me if I'm wrong, in my state, like in the state of Indiana, temp agencies, they're employed by the temp agency and they're contracted over. So, like, they're not actual employees. There might be states where temp agencies, I guess that'd be a recruiting office. The definition is, are they your employee or not? And if the temp agency you're working with, they don't become your employees until you hire them, that's when you have to fill in an I-9. If they're recruiting for you, but then they're your hire, I-9 is filled out. If you're working with a contract where the temp agency is the employer and you're just contracting their work for you, they're not your employee. You don't fill out an I-9. Was that as clear as mud, James? Do you want to make that clear?
No, I think that was great.
Okay.
I the what I've heard is best practices on previous trainings. Best practice would be to make sure that in your contract with the temp agency, you include a clause that says, that the temp agency will do their due diligence and be compliant with immigration law. But you don't have to fill out an I-9 if that employee's contract is with the temp agency. If their contract is with you or you are directly paying them, that is when you need to fill out an I-9 for them. Okay. Next is, are we required to keep photocopies of the documents that are provided with the I-9s?
You are not. That's one of those things where whatever you do, you just want to make it consistent. You're allowed to if you want to, but if you do, make sure you're doing that for everyone. If you just view them, they're the originals, you write in the information, and that's all you do as a business, you're also allowed to do that. So you don't have to. Some people choose to. If you choose to, just make sure that it's consistent. Because I-9s are one of these areas where like it's very easy to be like, wait a second, it seems like you're doing things different for different groups. You just want consistency.
Great. I would like to make sure that we correct something that was said earlier. you do need to have an I-9 on file, even if you are using E-Verify. So you do have, if even if you are using E-Verify, you do need to make sure that you have an I-9 for every employee as well. Um, the next question is, if I fill out my I-9s and keep them like on an HR software, am I also required to keep a hard copy, or can it just be kept in the digital format?
I don't know that answer. I'm not sure. I mean, my guess is, are they saying, I mean, if for whoever corrected the one we just said about E-Verify, they might be the one that knows this one too, that like,
Yeah, so I had texted one of our attorneys to make sure that we got the question right about the I-9s and E-Verify. I will also get that answer for you on keeping them. But on previous webinars, the answer has been no. You do not need to keep a hard copy. You just need to have the document and the information in the documents accessible to you, so that when DHS requests them, you are able to provide them. Okay. Next question is, if somebody is working for me with false papers, but eventually is able to get legal documents and they bring them to me as an employer, what do I do? Do I fill out a new I-9 with the new information?
yes, fill out the new I-9 with the new information, and then you'd staple it to the old I-9, and you'd want to like put a explanation saying, the employee brought me new paperwork. We've corrected it on the I-9, and then, initial it and date it. But that's okay to do. That's what you should do. As an employer, there is no like adverse thing that happens when you correct I-9s when proper documents are brought to you.
And in that instance, when you fill out the new I-9, would you have their first day of employment when they first actually started working for you, or when their new document starts?
It would be when they first started working for you.
Okay, next question is, the I-9 form has been changed in the last few years. Do I need to refill out I-9s with the new version of the form?
No. Whatever the current document is when the first day of employee, that's what you use. So you don't have to go back through and do them. If you found that like in an audit that like someone works for you and you can't find theirs, you should do an I-9 at that point and explain and share. But yeah, if you have an I-9 in file and it's an old form, you don't have to update them.
This question is, if you find an error in section 1 of the I-9, can you correct it, or does the employee need to correct it?
The employee needs to correct it. So if you find an error, you would just call them in privately and explain like, hey, we noticed this when we were looking and it seems like, this is incorrect. And then the employee would be the one that would mark it out and then initial and date when the correction was made. And that's another thing I don't know if I mentioned, but like when you do an I-9 audit, you want to communicate with your employees. Like that's always best. Like we're not looking to get anyone. Like we just want to make sure these things are correct. And so we're going to be reviewing things. So we might call you in because we see something that needs corrected, but like this isn't about getting anyone, in trouble. We're trying to make sure that we're following protocol and laws. It's written. And so letting people know that so that there isn't like, rumors or like, oh, I don't know what's happening, or they're only looking for certain people. You just want to communicate effectively with everyone.
Great. We have time for one more question, and then we're going to move on. And like I mentioned before, there are over 100 questions that have been coming in. I tried to pick ones that have been frequently asked. We will potentially be working on like an FAQ document that we can share out after the fact too, that maybe answers a couple more of these questions. Um, and then I will also say, as Zach mentioned earlier, you should find an immigration employment attorney. Some of the questions that are being asked are great questions, but are very specific questions. to a very specific employer or a very specific circumstance. And so, if you need legal guidance for how to handle this very specific situation, this training and our answers are meant to be broad best practice guidance. If you need legal advice, you should seek that with an attorney that you have hired that is your attorney. Um, or continue or follow up with Zach at the link that we provided earlier, or follow up with us, and we will make sure that you get in touch with the right person. So the last question before we move on, Zach, can you just describe a little bit more detail in the difference between public space versus private space when ICE is executing a warrant?
Yeah, I was glad that was the question. I was going to say, if we don't touch on that, we probably should. Like, you need to sit down in your workspace and in your sectors and understand which is which. It's different for everyone. This is the big question. It's like in a restaurant, oftentimes public space is a lot of the space, but private space would be like, I can just walk back into your kitchen or back into your office. For a hotel, it might just be the front desk is the only public space, and anything beyond that would be private. I'm a pastor as well, and so most churches, it's a lot of public space, right? We let anyone in, and so like there isn't a lot of private space. Where schools, there's a lot of private space, hospitals, and so I think the key for you is as an employer and even with your sectors to kind of decide what is public, what is private, so you know. And a lot of us, it's like we know there's always some distinguishment where it's like at least in most restaurants, you would say, no one's allowed in the kitchen. That's private space. No one's allowed in the offices. But you might say, obviously, like front of house might be public. For most hotels, it's probably like you let people in your lobby and at your front desk, but beyond that, it's private. I mean, it's definitely private to get in any of the rooms or into your office. And so it is different in different sectors, but there is definitely public and private space. People have asked things like, I think signage is always helpful, but whoever your point person is and whatever the plan is, helping people understand there's differentiation. Most, parking lots would be public, but some aren't. And so just knowing those distinguishing things is a very, very, very important thing. Probably if we can rank them, it's like, find the attorney, train a point person, and then know those differences because that would help if ICE ever came that no, you can't go beyond that without a warrant. James, would you add anything else to that?
No, I think that was very
Okay.
clear.
Okay.
I guess the only thing that I would add is, even if it is public space, if they're on private property, you always have the option to ask them to leave, and request that warrant. So again, like as Zach said, you don't have to consent, you know, ahead of time. You can ask them for their permission to be there. If they don't have legal permission to be there, you can always ask them to leave. But again, just keeping a careful record of what happens, what you've asked them, what they've asked you, so that you can hand that information to your attorney when it comes to your defense, when it comes to working out the legal process after the fact is super helpful.
Thank you very much for your time.